Okay, are we live? Can we get started? Okay, so I just got the confirmation that we are live. Hello, everyone. Welcome again. We're about to begin another webinar at Drummond Advisors. Today, we'll focus on how to hire F-1 holders for your US company. This topic in this webinar is the follow-up of a similar webinar that we have done a couple of weeks ago, which was focused on the visa holder itself. So a couple of weeks ago, and you can check that webinar on our YouTube, a couple of weeks ago, we had a webinar where we focused on how you, as a F-1 holder, can be employed. What can you do? What are your standards to work in the US under an F-1 visa? In some cases you can, like OPT and CPT. Today we've shifted the focus and today we focus and we talk to the employers, how you can hire an F-1 holder. So if you are a company looking to hire an F-1 visa holder, what can you do? What are the points of attention? What's the compliance that you need to be, what type of measures you need to take to be in compliance, okay? And I have my colleague here, Chris Costa, from our immigration department. He will be covering the immigration aspects of this webinar. And we also have Adriano and Paulo Marcilio from our payroll team. They will cover the compliance from a payroll perspective. What are the forms? What are the taxes? Do you need to pay Social Security or not? Who pays the Social Security? So those are the type of topics that we're going to cover, okay? Before we get started, just to remind that this webinar was supposed to take place last Wednesday. We were scheduled to talk to you guys on last Wednesday, but then the Zoom platform had a problem. This happens once in a lifetime. And apparently worldwide Zoom was down exactly at the time that our webinar was supposed to go live. So we had to reschedule for today the 22nd, April 22nd. So that's why we had to change. So for those that were scheduled to watch us last Wednesday, this is the reason why we need to reschedule, okay? So let's get started. As usual, just a little bit about Drummond Advisors. Most of you, and I can see very good friends and clients here on the audience. Most of you know Drummond Advisors already, but just a snapshot, especially for those that do not know yet. Drummond is a specialized consulting firm in international transactions. We are a cross-border firm. We serve international companies and individuals on soft landing in the US, the inbound of companies and individuals to do business in the US. So if you're planning to establish your business in the US, or you're planning to live in the US, to move to the US, we help you with accounting, tax, and legal services, okay? Myself, I'm the head of the legal segment. I'm a lawyer licensed in Brazil and the US for the states of New York and Florida. And Chris Costa here is also a licensed attorney in the US. He focused on the immigration, one of our senior immigration lawyers. We also have certified accountants, the so-called CPAs, and tax specialists as well, to help with accounting and tax. Our offices are in Boston, Miami, Orlando, São Paulo, and Belo Horizonte. We have boots on the ground on these 5 cities, more than 14 years of experience. We have served more than 11,500 active clients. And nowadays we have a team of more than 300 professionals, and among them, the other 3 guys that are going to be here with me that are very, very special people, very knowledgeable. And thank you very much, Adriano, Paulo, and Chris, for being here with us. Your experience is highly appreciated. just an idea of the type of companies that do retain us. These are some of our clients. So we serve clients of all sizes and segments. So no matter whether you are a large corporation, public traded, or whether you are a small company, we are here to help. Okay. That being said, let's jump to the subject matter of this webinar, how you, an employer, can retain an F-1 visa holder. What do you need to pay attention to? And just a housekeeping note, send your questions. Okay, we're gonna have some time at the end of the webinar to answer questions, but you can send throughout the presentation, and I may pick your question during the presentation, or I may save your question to the end. So send us questions is always very, very important. Okay. Chris Costa, welcome again. 1 week delay because of the Zoom problem last week, but here we are.
Huh.
Good
Yes, yeah, looking
afternoon.
forward to this webinar.
Yeah,
Nice to be
the
speaking.
floor is yours, my friend.
Thank you. Yeah, nice to be speaking from the perspective of U.S. company now rather than an international student. We see with our clients often that sometimes they're among their first hires within the U.S. Uh, Oftentimes are international students. Sometimes they advertise with local schools or have certain like partnerships. So the the immigration compliance aspect becomes important. Sometimes they're used to the documentation for maybe like an executive's visa, but not necessarily the intricacies that come with the F-1 visa. So here, our objective is to provide U.S. employers with a basic overview of the legal bases, procedures, and documentation required for employing international students. So international students on F-1 visas can obtain employment authorization through either Curricular Practical Training, CPT, which is usually like a part-time internship during their academic studies, or optional practical training, which permits full-time work. It's typically after graduation. Technically, it can be done during the course as well. There's something called pre-completion OPT, but in general, it's after graduation. Students in all professional degree programs will receive 1 year of employment authorization after graduation, and students enrolled in STEM programs, science, technology, engineering, and math, can qualify for a 24-month OPT extension, provided they, have a company that's, sponsoring this employment.
Okay. Chris, so a question for you to clarify, just being very practical to companies that are watching us. So basically, usually employers think that students cannot work, and that's the rule. Employers are right in thinking this, but then there are exceptions, right? And the exception is some students in certain situations they can work. Therefore, you employer can employ that student, even if that student is under F-1 visa. That student will be either under what we call CPT or OPT. But you, as employer, you will not ask, oh, are you under CPT or OPT? Nor are you going to have a document that they show this to you. The document that the student shows to you is the EAD. Is that correct, Chris? Or what document the student will provide to the HR department? What does the employer need to look for? We're going to
Mhm.
talk about the I-9 down the presentation here. Paulo and Adriano will discuss the so-called I-9. But what does the employer needs to obtain? What else when we talk about the EAD, the Employment Authorization Document?
So, international students have to register their employment with their institution of higher education. And that's done through a form called I-20 that's registered with CVIS, the uh, International Exchange Organization. Uh, so that form I-20 would either register CPT with the employer or OPT with the employer. That's the maybe basic documentation. And then there's a difference between CPT and OPT. With CPT, the student wouldn't have an employment authorization document because CPT is more like an internship, like I mentioned. The rules are a little bit different. It's also only up to part-time, so it's like, just a few hours during the week, basically. But OPT could be full-time work, and in that instance, the student would need an employment authorization card issued by USCIS.
Okay, there we go. So let's move forward.
Mhm.
Oh,
Yeah,
there we
so
go. The documentation for hiring international students. So yeah, but
mhm.
go ahead. Now we have the slide of what you were talking about.
Yeah, so this is maybe like the fuller picture of the documentation that the employer would require. The I-20, for somebody that is initially obtaining this employment authorization would be the first step, but then these documents would be required. These documents are really more for hiring somebody with OPT rather than CPT because that's the more traditional situation. And like I mentioned, people with students with CPT, wouldn't have an employment authorization document. Not yet. They probably would later after they obtain OPT. So the EAD, employment authorization document, is issued by USCIS. Students can pay an additional fee, to obtain the document faster. This document is required for like the onboarding on payroll, which we'll mention later. Uh, Social Security card is also necessary for entering payroll, and it'll be issued after the issuance of the employment authorization document. These two documents kind of go hand in hand for uh, temporary immigrants, non-immigrants as they're called. Uh, and then a copy of the passport and Form I-94, which is the customs entry document. Yeah, those documents would be required as well. And just a little disclaimer is that, these documents take time to be produced. Students, should consult their schools about, when they can uh, obtain their I-20 because, the sooner they obtain their I-20, the sooner, they can apply for employment authorization. They can pay the additional fee, but that would give them a response within 30 days. There's still uh, somewhat of a process behind this. So
Good
employers should
point.
just, be aware of these deadlines.
Good point, Chris. And that applies to any immigration task or matter or document that you are looking for. The sooner the better. Immigration processes, they do take time. So if you know what you need to do it. Do not delay in any point, okay? Whether you are a student or employer, act fast, okay?
Oh,
Go
Pedro,
ahead, Chris.
just
Yes,
should
Adriano.
can you back for just for the documentation just to add something
Sure.
here?
Mhm.
That's really important to let everyone know because that documentation we are talking about the students, but it will be applied for a W-2 employee. So we have some fi fiscal documents that we need to um, requests for the people that are entering the company, like the W-4 form, the bank account informations, and also some state forms that it's really important to know because we have some withholding tax and things that we will develop uh, when we start to talking about the payroll with Paulo. But just this mention to know that this document is important, but you also have some additional documents that we need take care and request for the employee, this student to start in the company.
Okay, good point, Adriano. Good point. And that will reflect on tax withholdings. As Adriano
Yes.
mentioned, we're going to talk about tax withholdings and other taxes like social security payments and etc. Few slides ahead. Chris, what are the most commonly used visas after the student finish their program, and if the employer wants to hire that student on a more um, it's still a temporary still a
Yeah,
temporary
or long
position,
term.
but it's a long term in a longer term.
Mhm. Yeah, so like I previously mentioned, all international students in professional courses excludes English language, but certificates, bachelor's degrees, masters, they'll all have 1 year of OPT, employment authorization. Students in STEM fields will have an additional 2 years for a total of 3 years. But this time period could be short, especially considering immigration processing times. These are the three main options that F-1 students would have. The first, the L-1 visa, is an intra-company transferee visa. It's for students who previously worked at the sponsoring US company for at least 1 year within the previous 3 years. Uh, Small exception if they started assuming work in the United States for the same company, but assuming that they came to the US as students not working for the foreign multinational company. The L1 visa would probably be their best bet. If they held a position that could be uh, classified as executive, managerial, or specialist, specialized knowledge, specialized internal knowledge, then there are a few like subcategories. But if this is the situation, then this would be a good temporary visa. Uh, the foreign company and US company, I guess, would have to have a certain uh, stature in terms of revenue and employees. Basically, they just can't be too small. They have to have a certain organizational hierarchy. Uh, but if this situation exists, would be a good fit. The next option would be the O1 visa, extraordinary ability, generally for people that have a little more experience, maybe international students that are here completing a master's degree or a shorter duration professional course of like, a year uh, or two. Uh, it can be for people in the arts, sciences, education, or business. We would have to show that, they've sustained national, international acclaim. And there are a few criteria that the government uses to judge that. Basically, it all comes down to industry recognition, like, maybe a certain experience at like prestigious companies, high remuneration, awards, publications, etc. We listed, a few of these uh, examples here, and from the perspective of international students, something that we discussed in the previous webinar, it would be beneficial for them to maybe continue building their portfolios. While studying here, certain criteria are, maybe closely tied to academic work as well, like publications, awards, for example. Uh, so yeah, this would be an option for your international student that maybe has some work experience or received some substantial recognition within the field. The standard option for international students is the H-1B visa. It's destined for people with a job offer from a US company in what's called a specialty occupation, which is an occupation that requires at least a bachelor's degree to enter. Uh, the issue with the H-1B visa is that there's a cap of $85,000 and there's 85,000 visas, sorry. and there's an annual lottery that occurs at the end of March of every year. So the issue is mostly selection because they're typically uh, maybe like 4 times more applicants than uh, available visas for international students that are studying in STEM fields. They at least have, let's say, 3 or more chances to participate in the annual lottery if they maybe participate during their course of study and the 3 years after in OPT.
Yeah, good points, Chris. And for you in the audience as employer, the company is the petitioner for each of these visas, okay? So it's your duty, it's your task, it's your petition, okay? The company petitions to the benefit of the individual. So you, the company, will sponsor an L1 visa petition. You, the company, will sponsor O1 visa petition. You, the company, will file a H1B visa petition to the benefit of your employee, that student. Okay. So it is very important for you to understand the requirements of each and choose wisely which visa is the most appropriate for that employee. Okay. Uh, Going forward, here are some exceptions where the employee can file on their or by himself or by herself, but that can also be filed by the company. The EB2, EB1. But go ahead, Chris, please explain each.
Yeah, so these are examples of the most common green card pathways for international students. Uh, I'll be mentioning later that the green card based visas are generally subject to longer processing times due to quotas. So it it would be likely that the international student would go from an F-1 student visa to one of the temporary visas that we mentioned, and then transition to a permanent visa as a green card holder. First option would be the second priority classification, national interest waiver in the EB2 category. It's for professionals with a master's degree or bachelor's degree plus 5 years of progressive experience. And the most important part would be a proposed endeavor that's deemed to be in the national interest. That would maybe depend highly on the field of academic and professional qualification. Uh, right now, the government is very interested in people uh, that are skilled and distinguished in fields of technology, working with uh, emerging technologies specifically, and uh, maybe even better applying them to manufacturing or industry. But those aren't exclusive proposed endeavors. Next option would be the EB2, EB3 perm. This is the standard employment-based green card where a U.S. employer tests the labor market. There's a long process with the Department of Labor, and then after the Department of Labor approves, then the employer can submit an immigrant petition to USCIS. Uh, this process can only be done by a U.S. employer, uh, and it requires that test of the labor market that I had mentioned. The other option is the EB1. It's last, not because of I guess uh, benefit, but just because it might be the most less common or more difficult situation in a way for an international student to qualify. Uh, but in terms of processing time, this would be the fastest because there are generally visas available. Uh, so the EB1 visa can be for people with extraordinary ability in certain areas within business, science, multinational executives. Generally, they would have the L1 visa that I had previously mentioned. Uh, or outstanding researchers. So generally, these visa categories would be for more experienced professionals, either professionals that are recognized within the industry or people with maybe more employment experience abroad, or distinguished researchers, which is a common and popular category at the moment.
Okay.
And yeah, like I'll mention, it's essential to plan long term because all of these options take take a long time.
Sounds good. Thanks, Chris. Thank you. Guys, so up to this point here on the webinar, you learn what are the options from an immigration perspective on hiring a student. Once you determine that you can hire that student and how, then you enter on some labor law aspects and compliance, meaning, okay, I can hire that person. Upon hiring, what are my rights and obligations as employer? First of all, the labor relationship between the employer and the employee, meaning the employee, an F-1 holder on OPT, CPT, or transitioning to another visa, it is a regular labor relationship as if you were hiring any other person, except for the fact, of course, that you need to double check other documents. But the labor relationship is still the same. Okay, it doesn't change the obligations that you have towards your employee. For example, employers cannot discriminate employees, whether that employee is a student or not, whether that employee is a foreigner or not. So keep that in mind. The nature of the employment agreement continue to be an at-will basis, the nature of at-will. What does that mean? It means that the agreement can be terminated by either party with no reason whatsoever, and as a rule, without prior notice. You don't need to give a certain period of notice unless the parties agree otherwise, of course. But as a rule, it will be an at-will basis, okay? That employee can be full-time or part-time, depending again on the EAD, whether it's CPT or OPT, etc. It will change a little, but as a rule, can be full-time or part-time. You need to check if the university has any special policy for your student, because sometimes that employment can be mediated, can be the university or the state can serve as the liaison between you and the student. So check if there is any special policy. International policies to hire international students, it's not mandatory. You don't need to have internal policy to hire international students. But if you want to have one, just to set the rules and the expectations, a certain business model on hiring and training international students, it is a good practice, and we recommend if you plan to have an ongoing program of hiring international students. The benefits to international students can be the same as a regular employee. Again, the rule of thumb is always do not discriminate, okay? If you offer some benefits to your regular employees, you will offer usually the same benefits to your international students, okay? Chris, we're going back to you to talk to visa bulletin, and then we close the immigration portion of the webinar, and then we move to Adriano and Paulo to talk more on the payroll aspect. But before we close that chapter, a question that came up here from two people already, and I want to address that question. Question for you then. Let me read that out loud. Are there any restrictions on the kind of work F-1 students can do while on OPT or CPT? In other words, what are the restrictions on the kind of work that F-1 students can do?
Mhm. So, as part of OPT compliance with the university and obtaining the Form I-20 that I had mentioned, the company has to sign a training plan for this employment. So the purpose of this employment is for the student to receive practical training relating to their coursework, the degree they're trying to obtain. So that training plan, would kind of specify the boundaries of the employment. Basically the employment can't be like primarily like kind of like as a getting coffee, like doing like more menial tasks. The person has to be obtaining actual experience relating to their coursework.
Sounds good, sounds good. So quick note on processing times, right? As we mentioned, everything takes a while on immigration. Processing times in the so-called visa bulletin. What does it, what it is?
Yeah, so as I had mentioned, the permanent visas, they are subject to quotas. These quotas were established like over 30 years ago. They don't meet the current demand. The Department of State publishes a monthly visa bulletin. Everybody here can Google it. Uh, Basically, well, the quotas are also they're established per visa type, and then there's a requirement that no more than 7% of the total visas in the category can go to people of a certain nationality. So in practice, this leads to a longer delay for people born in India or China, but for people from other countries, they're subject to the standard backlog. For the second and third categories, there is currently a backlog of about a year and a half for the second category and like a little over 2 years for the third category. Uh, so this is something to keep in mind. Like I had mentioned, most of the times somebody would be in a temporary visa while they await processing for a permanent visa. Very common, due to the long time frame.
Sounds good, Chris. There is a very interesting question from Andre regarding an L1 visa for you. But I will save that question, Andre, if you don't mind. I will save to the end so we can keep moving here and get Adriano and Paulo to the stage, okay? So everyone, you have determined that you can hire that student has the appropriate paperwork, the documents, and etc. Then you have learned that your rights and obligations as employer are quite the same as a regular employee, so that will basis and etc. Okay, so then you hire that person. Okay, then what are the practical day to day? And you're gonna be that person will be on the payroll. What's the process? What's an I-9, expiration date, and etc. Adriano and Paulo are from our payroll team. Guys, the floor is yours.
Thank you, Pedro. Exactly, we're going to talk about the practical part here after the hiring process up to the payroll. And we receive this question a lot if the F-1 visa student can be a regular employee, like a regular W-2 employee in payroll, receiving gross salary and paying taxes like everyone else. And as Pedro was telling us, an F-1 visa that you hire will be subject to the labor law just like everyone else in your payroll. So the answer is yes. Um, Not only you can, but you must treat him just like uh, every other W-2 that you have in your payroll in your company, right? And we have some special needs that you as an employer needs to take care of when you hire an F-1 visa student as a W-2 employee in your payroll. Um, besides the fact that he holds a F-1 visa, the admission process in terms of payroll, it's basically the same as the other W-2's employees you hire. So you need to have an offer. He has to accept this offer, or if it's the case, you have to have it sign a employment agreement, and also following the mandatory forms that you need to get from your employees, like W-4 for the IRS side of taxes, I-9 that we are going to talk a little bit further in the presentation, and also depending on your state, withholding certification, just like every other W-2 employee. What are the special attention aspects that you need to have while hiring an F-1 visa employee? Is exactly on the I-9 portion of the mandatory forms, because as Chris was telling us, the F-1 visa holder, he have some he must have authorization to work, and this is something that us in the payroll department, or you as an employer, your HR department, needs to be very careful while verifying the admission documentation. In the I-9 section, there's some important information that you will have some tips on the visa status of the employee, and also in this case you will need to verify additional documentation, not only the I-9 form signed, but in this case your employee will need to give you some additional documentation to prove the visa status, the OPT or CPT status, and if it's the case of the OPT, the EAD, the authorization to work. And something that is very sensitive for the company to be aware of is the expiration dates, because as Chris mentioned, the F-1 visa will not uh, will not be a forever visa status. So it's very common that we receive some payroll consulting to take care of some cases that clients didn't take care of that. So the employee was with a wrong setup in the payroll due to his F-1 visa status has expired, and the person that was taking care of the payroll wasn't aware of that, or the employee wasn't aware of that. It doesn't matter. But if the expiration date comes and you don't take care of the payroll side of the setup of the payroll side, you and your employee must be in trouble with IRS, and no one wants that, right? So you need to be very aware of the expiration dates of the visa status. We can move forward
And
to the
guys,
next
very
slide.
interesting questions coming up
Mm,
from the audience. Mostly are immigration related. Given that we are already on a payroll, I will save those questions for later, to the end of the webinar. But Chris and I, we're already here. We can see the questions, very interesting questions on change of status, F-1, students being owners of the company. There are several interesting topics to cover. Go ahead, Paulo. Next slide. The Form I-9, the so-called
Form
Form,
I-9.
very important.
Yes, very important. As I was telling you, the one of the mandatory admission documentations for a W-2 employee is the I-9 form, and especially this year after the government changes, there are some new there are changes that are happening in the form from 2025 beyond, and I would like to ask Adriano to tell us about it. We have some cases here with our clients, so it's real. There are changes, and you need to be very careful with Form I-9 to all the W-2 employees, but they're especially for F-1 visa holder.
Yes, yes. So that's one of the most important document when you're talking about the international student. So this document it's really important because uh, he it will determine if the employee is eligible or not to work and give all for us the all the important informations that we have to enter this employee in the payroll. So some tips that we have here, the website, there's a website that's the USCIS that will explain for you guys how this document need to be completed. The first section will be completed by the employee, and this document should be completed after this exception of the job offer. So this employee cannot to complete this document before accept this job offer or the employment agreement in this case. And the second part is important because the employer will need to review this document and all the documents that the employee, the worker, international students will provide and validate this document. So there's some system that you can use or you can do a manual review of this document. One of the most important and the most common system used is the Verify. It's a government electronic system that you can upload that all the documentations and make this verification. You need to put in your mind that this documentation can be or not be acceptable because you have three lists of documents. The list A will let the employer know the identity and the work authorization. So the list A usually are a passport or employment authorization card with a photo and the personal informations. But also sometimes the worker don't have this kind of documents and they have a different one. And the list B and C need to be combined for these employment authorization and identify the employee. For example, you can use a drive license as a identification of the employee with a photo, and you can use the social security card with some restrictions, but you can use that. So that's a real important document, and you need to verify this document 3 days after the employee start to work. So you cannot do it later, but you can re-verify this document after some days or some updated. So this document is not only for non-immigrants. This document need to be for U.S. citizen also. So that's a really important document to have on file, have updated, and don't have troubles with Department of Immigration, Department of Labor, and also with IRS.
Perfect, Adriano, perfect. Guys, and especially nowadays that the immigration enforcement is enforcing even more the laws and regulations, the so-called IC, the immigration police, is implementing some raids on and inspections on companies and employers. That's a document that they ask for. So you need to have on file. Okay, we can help you on um, educating you guys on how to file, how to obtain this information, when to have this form done and completed, and so forth. Never, ever forget about the Form I-9, okay?
Perfect, Pedro. Moving forward here, we are going to talk about Social Security taxes. Um, the general rule. So we're not talking about only F-1 visas here, but the general rule for every employee in the U.S., every wage that you pay to resident aliens employed within the United States are subject to Social Security and Medicare taxes, the so-called FICA taxes, right? And wages paid to non-resident aliens, in general, they are also subject to Social Security, Medicare taxes. So, in summary, the general rule are wages paid to an employee, you have to pay, withhold and pay employer social and Medicare taxes. But there are some exceptions. And when we are talking about F-1 visas, the employer can be use this benefit that IRS gives you as an employee, as an employer. So we can move forward to the next slide to go. Um, yeah, let's talk about the exceptions here, right? So some classes of non-immigrant and no-resident aliens can be exempt from those taxes, Social Security and Medicare taxes. Um, Usually they are students, scholars, professors, teachers, trainees, researchers, and other aliens temporarily present in the United States in F1, J1, M1, Q1, and they're not very common for us, but F1 that we are talking about here is listed here. So if you hire an F1 visa holder as your employee, be aware that you can have tax benefits with that. Um, we can move forward for the next slide just to look further into this subject. Yeah. So F1 visas, they can be exempt to they are elected to not withhold the social security tax and Medicare tax portion of their gross amounts in the payroll. And also in the employer side, you as an employer will be exempted of those taxes too. So there's a cost benefit there for your company. The exemption does not apply to spouses and children. So sometimes we receive these questions from clients, but only the F1 visa, for example, will be eligible for the exemption. The exemption does not apply to employment not allowed. This is logical, but it's important to to double check, right? And the exemption does not apply to non-immigrants in F1, J1, M1, K1 who become resident aliens for tax purposes. So it's very important to be aware that even if you are F1 visa for a while, you may be considered a tax resident for tax purposes to the IRS. And but there's an important rule that we always take care of that is listed in the very end of the slide. There's a 5 years rule that can be applied to the F1 visa, which means that F1 visa can use this exemption benefit, tax exemption benefit, for 5 years in tax return. And but even in this case, it's important to always be aware of the substantial presence test that IRS mentions to double check if you are or are not a tax resident for tax purposes in the US. If you are not, you can still use for 5 years this tax benefit in for social and Medicare taxes. And in this case, the employer will be also eligible for the tax benefit in the employer portion too.
Sounds good. Sounds good. Paulo, thank you very much. You covered precisely everything we needed. Adriana, thanks again. Chris, thank you very much. We're finishing the content just 10 minutes in advance, so we have plenty of time to go over the questions, which are very, very, very interesting. Before I jump into the questions, on your screen, guys, you have our contact information, okay? You have my email and my LinkedIn. You can also scan the QR code, which will lead you to my LinkedIn and so forth, okay? Adriano is here as well, his LinkedIn, his email at Drummond Advisors as well. Send him a message, send him an email. We're happy to talk directly with you. Paulo Marcilio, here it is. His QR code, LinkedIn, and email. Paulo is also our best guitar player in the company. So if you need someone to play guitar in your party, contact Paulo, right, Paulo?
Yeah,
I
why
have some
not?
commissions on that. Okay, if you get hired to play guitar, I have commissions on that. And then Chris, our senior lawyer for immigration department, his LinkedIn and the email. Some questions here that I will go over will lead to further questions, or sometimes very specific to your case. If that's the case, if that happens, send us a message, send me an email. I'm more than happy to speak directly with you about your case, or Chris, or Paulo, or Adriano. Okay. Here's our contact information for the company, uh, our social media on Instagram, on LinkedIn, on YouTube. Add us, follow us on social media. We have way more content like this one on our social media. Okay, so let's get to the questions. One that's very interesting and comes up a lot. Chris, here's the question, and then I will rephrase to have it even broader. The question is, could a F1 visa holder be a minority shareholder, meaning a minority owner of the company hiring him? So I will make that question even broader. Please discuss ownership versus visa for the F1 visa. In other terms, can the beneficiary, the student, the F1, be minority owner? What about a majority owner? So in what circumstances can the person own the entity and at the same time be the employee and still benefit and still apply for OPT or another visa?
Mhm. So for OPT, USCIS has recently relaxed the requirements around basically self-sponsorship, where uh, somebody with a majority ownership in a company, sponsors their own OPT. That's now allowed, and I guess it was uh, altered maybe to facilitate your tech founder establishing a startup shortly after completing a course of study. Now for the STEM extension, which is the additional 2-year extension of OPT for people that studied science, technology, engineering, or math, the rules are a little stricter, and technically a majority owner can apply, uh, but there has to be somebody else at the company with like an elevated position that signs the training plan. So, in practice, it might be restrictive, and if uh, the the F1 visa holder is, like the only owner, then maybe it wouldn't be viable. This other person that signs the training plan in an elevated position also can't be an OPT themselves.
Okay. That question came from Andy. Thanks, Andy. Very useful questions to several other people here. Um, Another very interesting question. F1, let me see where it is. Are OPT and CPT valid for change of status, Chris?
Mhm. Yes, as long as non-immigrants are in a valid status in the United States, they can apply to change status within the US. F1 students also have a 60-day grace period upon completion of OPT, for the purpose of allowing them to either organize themselves to return abroad, or maybe uh, an extended period of time to obtain uh, employment sponsorship. The they can benefit from a change of status during the 60-day grace period following OPT as well.
Okay, okay. Let me pick another one. Um, can English as a second language schools offer CPT for students?
No, yeah.
Big
Uh,
no.
ESL is maybe a course that people can take initially to prepare themselves to enter uh, like a master's degree program or a professional certificate program, uh, which would allow for CPT or OPT.
Okay, okay. Interesting questions coming from, let's see. Um, just a follow-up question from Patrick here. He has, if I have an LLC, is it possible to hire myself for OPT? That goes to the initial question, Patrick, whether you can be a majority or minority holder, minority or majority shareholder, minority or majority owner of the entity. Okay, that's what Chris just explained. That in some circumstances, yes, the USCIS has relaxed some criteria, but it's not that straightforward. Okay, it will depend on the circumstances, right, Chris? That's the
Yeah.
same question, okay, Patrick, that we hired. Andy Mendes, Andy again, Andy on a very important and follow-up question. Thanks, Andy. Same question, Chris, but on H-1B. Okay. Please discuss ownership versus hiring myself on H-1B.
Mhm. Yes, same answer actually. USCIS also relaxed majority ownership for H-1B purposes. It's something very new that they really did within this last H-1B fiscal year. So we're still gonna kind of see how that's implemented in practice, but in general, a lot of immigration attorneys have been discussing strategies about how to make that work possibly, for your uh, tech company founders, for example, having it also kind of for H-1B purposes, another related issue is whether the company has uh, revenue or the prospects of revenue. That actually isn't very important for OPT, but it's very important for H-1B because the company has to be able to evidence that the beneficiary will have sufficient specialized specialty occupation work for the duration of the period requested. So for a more established startup, it can be more viable than a completely new startup for H-1B purposes.
Okay, okay. Uh, questions from Andre. Andre is asking on L1, can I apply for an L1 visa from a European company? So the case is there is an European company with a US subsidiary. Andre is asking, can I change status from a F to an L, and the US entity has only one employee? And then his follow-up question is whether if this is too hard or too difficult, E2 visa would be a possibility if that person is Portuguese. Andrea, answer to your question, I'll pick this one, Chris. Yes, you can apply for change of status from F to L as long as all other requirements of an L is present. Okay? And then specifically to your case, you need to check whether that person has been in a full-time position in Europe on a managerial or executive position, whether that person will function on a managerial or executive position in the US. And here comes a problem, among other requirements, okay? But specifically to your point, if the US subsidiary has only one employee, it might be a hard case to convince USCIS that you will function at a managerial or executive position. In other words, you can apply for a change of status, but your L1 might be hard to obtain. If that's the case, then a E2 would be an option. Well, if you are a Portuguese citizen and the company is owned by a Portuguese individual, an E2 is an option. Why? Because Portugal has recently signed a treaty a treaty to be to allow E2s. Okay. Again, that's very specific. It's very case specific, Andre. So feel free to send us a message, and we can try to assess what's the most viable possibility for you. Interesting case. Answer is you can always apply to L1, change status to L1 as long as you have all other requirements. Okay, guys, we are completing 1 hour. We have more questions here. They are all very interesting questions, but in the interest of time, and we will finish it up. Chris, Adriano, Paulo, thank you very, very much, especially to Adriano, who brought this topic and asked us to talk to students. It was a great idea, Adriano. We are completing these 2 webinars to talk about students in the US, for students and for employers. I hope we have added value to you guys in the audience talking about this topic. Last but not least, thank you very much to our communication department. Today we have Aline with us, helping us in delivering this webinar. A webinar like this one doesn't come out of the blue. There are a lot of people working behind the scenes to make this happen, and these people are from our communication department. Thank you very much. I hope we could provide you guys with valuable information. Chris, Adriano, Paulo, thank you very much. Your last words before we go. Thanks, Chris. Thanks, Adriano. Thanks, Paulo. Thank you, everyone.
Thank you, guys. Thank you.
Yeah, feel free to reach out with any U.S. immigration questions. Our pleasure.
Thank you, guys. Bye-bye.
Bye-bye.